Sure. My name is Neal Katyal, and I'm a law partner at Hogan Lovells, where I co-direct our appellate practice, and I'm also a law professor at Georgetown. So when I filed the case initially with my amazing co-counsel, Lieutenant Commander Charlie Swift of the U.S. Navy, the JAG Corps, and Perkins Coie in Seattle, because we filed the case in Seattle, I didn't file it in order to be some litigation maven or something like that. I just filed it because I had some thoughts about how to frame up this case in a way that could win, and to do it in a respectful way to the executive. And so that's why I did it. And as the case went on and on, my kind of debate background and my kind of legal training and stuff kicked in, and I thought, well, this is actually kind of fun. But truth be told, the Supreme Court, when they granted cert in the case on November 7th, 2005, between November 7th, 2005, for the next couple weeks, I thought about, and I did try and give the case away to various established Supreme Court litigators, because when I was clerking, saw so many people keep their own case and fall on their face, and that was the last thing I wanted to happen. This issue was really important, and ultimately I wound up keeping the case. It was a long story. In part, there were conflicts among other people. I'd approached Ken Starr, among others, and then Congress did something really unusual. A few days after cert was granted, they decided to try and strip the Supreme Court of the ability to hear the case, something that hadn't happened since the Civil War. And so this case became really huge. And a lot of the law firm practitioners that wanted the case, I was just worried that it was just going to be, another case for them, and I wasn't sure they had the time, particularly now that the case had become so astronomically huge. I mean, there were thousands and thousands of pages of briefs, I think 40 different amicus briefs and the like. And I said to myself, okay, I'm going to do this, but, I'm going to do everything I can. I might fall on my face, but I'm going to do everything I possibly can to do the best job I can. And so I remember I took a legal pad out of paper one night, and I said, who are the people who scare me the most in the country in terms of like the lawyers who could moot me? And I made this list, and I remember it had Elena Kagan on it, and Harold Coe, and Lawrence Tribe, and people like that. And I called them all up and asked them, would you moot me? And it was remarkable. Cross-section of people, politically left and right. Everyone agreed to moot me except for one person, and I had so much respect for this. Charles Fried at Harvard, former Solicitor General, said, Neal, I could tell you that I'm just unavailable on that day and refuse to help you for that reason. But the truth is, I want to be honest with you. I don't want you to win. And so I'm not going to help you. And I thought that was also sweet in his own way, and Charles is wonderful. But I did go around and moot the case. And I remember at my very first moot, was at Harvard, and Larry Tribe, among others, was there. And I remember Larry saying, we were in this huge Ames moot courtroom, it holds like 500 people, and it was me behind this podium and they sitting up high on the bench. And he said, Neal, you sounded a little small at the podium. And, I did. I sounded kind of a little timid and not directing the argument in any way. And I didn't really have presence. I was too focused on my legal notes and, trying to make every possible point the way I used to in debate. And Charlie Swift, my co-counsel, said to me, I have someone I want you to meet, because I think he can help you. And I said, all right, I'm happy to take any advice on this at this point. I'm about to argue this huge Supreme Court case. I'm scared out of my mind. He said, look, this guy can really help you. So this guy comes in one day, and he is not a lawyer, and he's an acting coach, and he's wonderful. And he says, I just want you to practice your argument. And I grab my legal pad, and he says, no, give me your argument. Look at me. Don't look at your legal pad. And so I did. And then he says, no, I want you to practice it holding my hand. Practice your argument holding my hand. I was like, this is really weird. But the truth is, it really did help. He understood that what appellate advocacy is, particularly at the Supreme Court, it's really intimate. I mean, you're just a few feet away from the Chief Justice. If you're sweating, they see you, and it's a conversation. And if you're looking down at your legal pad the whole time, you're not going to have that conversation. And he really helped me see that and break through and understand that. And that is something that, I have tried as an advocate, but also as a teacher, to really emphasize to my students that it's kind of, can you have a conversation with someone? You don't have to sound like a lawyer and be argumentative. That's the way to persuade someone, not, and to try and help the court in its search for truth. So, I do think that Supreme Court advocacy is a specialized skill, and it should be left to people who understand the court. That doesn't mean that a first-timer can't do a good job. I'd like to think that in Hamdan versus Rumsfeld I did, and of course everyone has to have a first time. My partner Dom Perella had his first time just a few months ago and gave a bang-up, awesome argument. Why? Because he understood how the court operates. He didn't just waltz in and say, "Hey, I got this," because I was the guy at trial. That wasn't it. It's because he really deeply watched a ton of Supreme Court arguments, had already written a ton of Supreme Court briefs. I had absolute confidence that someone like that could come in and do a great job, and he did. So I think that two things about the Supreme Court that make it different are, one, precedent doesn't bind the court. So in every other court, in federal courts of appeals, I and others are standing up arguing, well, the Supreme Court has said X, or this court has already said Y, and that's it. That's the game over. That's the whole thing. At the Supreme Court, you say that, and they're like, okay, but why should maybe we said it, but why should the rule be X? And that's what all the hypotheticals are getting at, and so on. It's a whole different profession, actually, at the Supreme Court than it is in ordinary appellate advocacy. And so if you're used to that, if you've seen it a lot, if you've written briefs that are geared to that, you're going to naturally be better than someone who isn't. So that's one thing. The other is just the physical dynamics of the courtroom, which make it really so intimate. And because it is that kind of, you're just a few feet away from all the justices, those folks who have a more kind of bombastic or argumentative style, I think, don't do as well as those who have a conversational style. And it's really, I think, important to see a lot of arguments before one argues in the Supreme Court. I'm fortunate to be helping run the practice that Chief Justice Roberts ran at Hogan Lovells when he was a private lawyer. And one of the things that he emphasized time and again was, it's not really about the counsel, it's about the justices, and they're having a conversation with one another. And we as the counsel can help guide that conversation, can make the strongest points on one side or the other. But ultimately, you have to realize that when you're arguing at that court, unlike virtually any other court with which I'm familiar, it's you're a facilitator more than you are kind of a arguer. So my oral argument preparation is pretty much now down to a science, since I've done 24 arguments and 22 of them have been in the last 6 years. So I've pretty much got this down. I don't know if I'm any good at it, but at least I got an attack plan. So basically, a few weeks before the argument, I'll read all the briefs and take very, very careful notes on them, type them all up. And then from there, I'll break down those notes into a long outline, kind of the way a legal course outline would work, with topical breakdowns by subject matter. And I'll make essentially a binder. And then a few days before my first moot, I will create almost a cheat sheet, a one-pager, that has all of my points for each major set of questions on it. And I'll just be constantly revising that binder and my cheat sheet. And the binder I bring up with me, I'm not as good as, Tom or Paul or someone like that who doesn't bring up anything. I always got my binder. I haven't had to look at it except once when it was a very technical question, but I like having it up there. The majority of my argument prep is done in the moots. I'm a firm believer in moots. I did 15 moots before my very first argument in Hamdan. I still will do as many as 6 or 7 in a big case. And it's also a part, I believe in that in two ways. One is it really helps me get familiar with the case, and I've hired, the best team of Supreme Court people around, so much so that I think in my 10 or so arguments at Hogan, whatever they've been, I don't think I've gotten a question at the Supreme Court that I haven't gotten already at my Hogan moots. The people there are that good. So one thing is that. So that's preparing me. But the other side of the moots is it's a way for the clients to really make sure that they're comfortable with my answers. Because I might know the legal answer to something, but oftentimes there are business implications, there are personal implications, all sorts of things. And if you have a bunch of moots, you're more likely to ferret out all of those kinds of questions and make sure that you as an advocate are saying the right thing. I mean, that's particularly true in my practice because we specialize really in cases in which there's a lot of other law firms involved and a lot of other clients involved. So, for example, I just argued earlier this month the natural gas case, the preemption case at the Supreme Court, which had 10 different energy clients, 10 different law firms. It's really important when you have that number of people to make sure that they all have heard your answers to a wide smattering of questions to make sure there isn't any divergence among the client group. And that's just a natural facet of kind of litigation involving multiple players. So I'm a big believer that the briefs are the most important piece. I know that the oral advocate always gets a certain amount of the sizzle and flash, but at the end of the day, it's how well that legal brief is crafted. And for me, in my hiring decisions over who I'm going to hire, I probably spend more time thinking about that. Who's a great writer, but not just a great writer, who's analytic? Who's got that kind of power to really understand what the case is about, what the tensions are in the case law, and so on. And so, I spend a fair amount of time on the front end when we're filing briefs, making sure that they're crafted in the right way. Because if the brief's done well, then the oral argument is going to go a lot easier than otherwise. And every so often I'll pick up a case that's been briefed already, and that sometimes can be challenging. So I have a couple of expectations when I go into the court. One is, unlike I think a lot of other people, I don't view any justice usually as out of bounds. That is, I think it's really important when we brief a case and when we argue it that every justice is seen as in play. That is, look, of course certain justices have different views, but I do think a lot of litigants have a defeatist attitude about this and don't understand that the justices are really are trying to do the right thing. They obviously have past positions, but your job as the advocate is to talk to them in light of those past positions. I mean, one very good example was Lewis versus City of Chicago, which was a disparate impact case that I had on behalf of 20,000 firefighters and applying for firefighting in Chicago. A lot of people thought there's no way the court's going to accept this and so on. 9-0 opinion written by Justice Scalia affirming this class action disparate impact in 2010. Hamdan versus Rumsfeld, another example, but there's so many in which I feel like oftentimes lawyers, interest groups, and the like abandon justices who otherwise might be in place. So that's one expectation. The other expectation, is that I'm going to get a question really fast. I'm going to draw one. And a couple of times I haven't had that. So I normally have like one line written down on my legal pad and, I can ad-lib for a little longer. But a couple of times, including in a big case, Ashcroft versus Al Kidd, in which I was defending former Attorney General Ashcroft for allegedly abusing people's civil liberties in the War on Terror, I didn't draw a question for a while. And, that was a little bit unnerving. I was looking at the courts and who's going to ask me a question? And, and I remember a couple of them grinning back at me, but didn't get a question, but finally did. But it is a very questioning court. That's what makes it so exciting. And I should say, unlike other parts of American government, this court works so well. I mean, these are 9 extraordinarily talented people. They're working super hard. They're analytic, they're powerful, they're rhetorically gifted. It's a real privilege and an honor to walk in there and help facilitate a conversation among them. So, I mean, in part because of the tradition of this firm and Chief Justice Roberts running our practice and the way he ran it, I think everyone here really believes very deeply our job is very simple, which is to provide a straight answer to the question and to be as forthright as we can with the court. That means acknowledging our weaknesses, acknowledging the strength of the other side's arguments, not using rhetoric to kind of paper it over. Obviously, we have a job to do, which is to win our case for the client. And we take that extremely seriously. But that's always done against the backdrop of what the court expects from us. And it's a real honor to walk into the court and to try and fulfill that mission as best we can. So I don't walk in with an argument tree or anything like that. I can't imagine that plan working. Instead, I recognize that there are 9 justices there who may have very well 9 different lines of questions that they want to ask me, and indeed all at the same time. And so you can flicker back from one line of questioning to another because you have so many people on the bench and because they're all so good and dedicated. And so it's natural to have that kind of cacophony of different questions and different perspectives happening. And so instead of walking in with an argument tree, I walk in with 2 points that I have at the top of my pad, which are the 2 things I want to leave the court with at the end of the day. Hopefully to try and get to them, to try and signal to the court, I got something important here. It's not just a line-by-line debater's argument, but this is the important point. This is the theme. And to try and structure a theme that questions that I'm getting, even if they're from disparate sides of the court and whole different areas of questioning, still somehow my answers yield back and come to some common theme. I guess that's what I'd say. It's obviously a difficult thing to do. And you never want to be the person trying to drive the conversation, I think, at the court too much, because after all, your job is really to answer their questions, not to give a speech. So I certainly don't think my job is just to be the counselor to the court in the sense of a law clerk or something like that, just giving, the most unvarnished, straight answer, which has no client goal behind it. Obviously, you're a lawyer for the client, so you have to, at the same time as being totally straight with the court, also make the best argument on behalf of your client as you can. And yes, you're going to get questions from a variety of different angles on the court, and your job is to figure out, before you walked in, what's your best answer to those questions, and B, try and weave those into the questions that you're getting. Well, it's hard as the advocate to know the importance of oral argument, because obviously that's a black box and we're not seeing it. I certainly think it's absolutely the case that people lose cases at oral argument all the time. They concede the wrong thing. They don't have a theory of the case. They don't have a rule that's clear for the court to understand. All sorts of things like that I've seen happen time and time again. I mean, I think I watched almost every argument at the Supreme Court from 2009 to 2011 because running the Solicitor General's office and being the principal deputy before that, that's what you do. And lots and lots of times you see people losing cases. In terms of winning time, I do feel like that happens too. It's a harder thing to test, and obviously the law clerks and the justices know it, but we as the outsiders don't. But my sense is that, yes, sometimes people come in and they explain why a position that a lot of people think might be unreasonable actually is reasonable. And it's not, again, rhetoric or something like that. It's actually that the position's really good and a lot better sometimes than the briefs have acknowledged. I've certainly had senses in both directions at oral argument, whether something is going well or not. I think, probably the one that sticks out the most in my mind is the very first argument in Hamdan versus Rumsfeld, in which, I was arguing against Paul Clement. It was probably his 35th argument. Such a beautiful advocate, it's just amazing. But I think his client had directed him to take a really hard-line position, so much so that Justice Souter got really, really angry at him, and Justice Souter, not someone to really flash his anger, but it was an extraordinary moment. And it was a moment in which I remember my co-counsel looked at me and said, "We just won the case." And I think in some ways that's right. Again, it had nothing to do with Paul. It had to do with the fact that the administration at the time directed him to take a really ideologically aggressive position. And I guess one of the things, it's about Supreme Court advocacy, but about government service more generally, is when there are a bunch of ideologues on both sides of every issue, and in general, those positions don't fare well at the Supreme Court. I mean, and don't fare well in practice. I mean, Guantanamo, these military trials, they've never happened. Been more than a decade since, and nothing's happened. They've never gotten off the ground. And so when you have kind of extreme ideological positions, and then you're trying to advocate for them in the Supreme Court, that's a tough position to be in.